Good morning, everyone, and welcome to this Evershed Sutherland PROPcast. My name is Caroline Andresier, and I'm a professional support lawyer for the Real Estate Practice Group here at Evershed Sutherland. So our subject today is Schedule 31 of the English Devolution and Community Empowerment Bill, which had its second reading in the House of Commons just last week. Schedule 31, which is fair to say came as something of a surprise, contains provisions that would render upwards-only rent review drafting in commercial leases ineffective, the so-called ban on upwards-only rent review. In this PROPcast, we'll consider the technicalities of the drafting of that Schedule 31 and its impact on the sort of rent review provisions we presently and commonly see in leases of commercial property of all sorts in England and Wales. I shan't be considering the wider politics or desirability of such a ban, or whether there was sufficient consultation or not, but I thought it was right to look at the technicalities of the proposals and their potential impact so that clients can consider whether or not to make representations against or in favour of the bill, or put forward cases for exemptions or exceptions or amendments to the present legislative drafting. It is inevitable, of course, that the drafting of the bill may well change as it passes through Parliament, through its committee stage, through debate and likewise. And what we have now may be very different to what finally gets royal assent. But if we want to understand and perhaps look to shape the resulting legislation, we need to look at the draft provisions carefully to see what they do and how they might affect the lease drafting we use routinely. Likely, whatever we end up with legislation-wise won't take effect until 2027, so we have time to consider and redraft as necessary. If anyone was so minded to find ways around the new provisions, given how much that would depend on the exact drafting, it's probably best to wait until we have the final statute and any accompanying regulations. Schedule 31 of the bill adds two schedules to an old familiar. It adds a new Schedule 7A and a new Schedule 7B to the Landlord and Tenant Act 1954. Schedule 7A contains 4 conditions. If those 4 conditions are met, the schedule applies to a particular lease and the ban on upwards-only rent review applies. So I'll now run through those 4 conditions in turn and we can consider their consequences. The first condition, condition A, is that the lease in question has to be one to which Part 2 of the Landlord and Tenant Act 1954 applies. That makes sense. After all, Schedule 7A is going to be slotted into the 1954 Act. The lease has to be one to which Part 2 applies. So that is generally leases where the tenant is in occupation for the purposes of a business. It's important to note that Part 2 of the 1954 Act still applies even if the landlord and tenant have agreed to contract out a lease from the security of tenure provisions of that Part 2, sections 24 to 28. So all leases where the tenant is in occupation for the purposes of a business have Part 2 of the 54 Act apply whether or not they're contracted out. So even if contracted out, a lease to which Part 2 applies will fulfill Condition A of Schedule 7A. So looking at that first condition, it's all about leases. It's not about licenses to occupy, not about management agreements, or perhaps in the data center word, co-location agreements, not about any overarching commercial agreement allowing for occupation. It's all about leases. But of course, the usual complications apply as to whether any particular agreement or arrangement is a lease or a license in the first place. But it is only leases here. It has to be a lease to which the 54 Act applies, so the usual 1954 Act exclusions still are relevant. So this condition A wouldn't be satisfied by a very short-term lease granted for a term of up to 6 months because the 54 Act doesn't apply to those sort of leases. Though, of course, they're so short, they probably wouldn't have rent review provisions in the first place. It wouldn't apply to agricultural and mining leases, service tenancies dependent on employment, that sort of thing. If the leases are outside the 54 Act in the first place, then they won't fulfill Condition A. Some of you might remember that once upon a time it used to be the case that some leases of licensed premises were excluded from the 1954 Act. though that provision was repealed in 1990. So there may just be a few leases granted quite a while ago of licensed premises that actually fall outside the 1954 Act. But actually, Condition A of Schedule 7A expressly brings those leases into Condition A. And remember that for a tenant to be in occupation for the purposes of a business, for Part 2 of the 54 Act to apply, the tenant actually has to be in occupation. So if the tenant sublets the whole of the premises demised by a lease, Part 2 will no longer apply. Condition A won't be satisfied, and as things stand with the draft legislation, any upwards-only rent review provisions in the lease wouldn't be rendered ineffective. I don't suppose a tenant would agree to include upward-only rent review provisions in a lease once Schedule 7A is actually in force. But if it did, those provisions would be ineffective unless and until the tenant sublet whole. Then the 1954 Act would no longer apply, Condition A would no longer be satisfied, the upward-only rent review provisions would no longer be effective and could actually work. Of course, the sublease, where the subtenant is in occupation for the purposes of a business, would still be subject to the ban. And as the draft legislation stands, there's the possibility of the tenant being caught in the middle, facing an upwards-only rent review under its own lease and unable to enforce that against a subtenant. And just as an aside, while we're talking about subletting, which is a slight detour from considering the conditions in Schedule 7A, most leases require a tenant to sublet on the same or similar terms to that of their own lease. So that could mean that a tenant has to include what might be ineffective upwards only rent review provisions in a sublease to fulfill the conditions around subletting in its own lease. It's rather odd. Looking at the second condition in Schedule A, Condition B, and that condition is that the lease is a post-commencement tenancy. That is one granted after Schedule 7A comes into force or granted under a contract entered into before Schedule 7A comes into force. So the good news is that any ban will be prospective only. Existing leases and their existing upward-only rent review provisions won't be caught. Not just a lease entered into after Schedule 7A comes into force, but a lease entered into pursuant to a contract before the schedule comes into force. So an agreement for lease now, an option to take a lease in the future, a tenant's contractual right to renew already contained in a lease, or a reversionary lease completed now, but with a term that starts somewhere in the future, all those would lead to leases not subject to the ban. So we might have upward-only rent review in leases quite legitimately for some time to come. There's no exception to renewal leases, whether renewed under statutory rights under the 1954 Act or otherwise. If a renewal lease falls into the definition of post-commencement tenancy, any upward-only rent review provisions in them would be ineffective. That's Condition B. So Condition C is where the lease in question is subject to what the schedule refers to as relevant rent review terms. Now, Schedule 7A contains several new turns of phrase that we're all going to have to acclimatise to, and relevant rent review terms is one such turn of phrase. So where the lease is subject to relevant rent review terms, whether contained in the lease or not, and those relevant rent review terms are where the amount of rent will or may change during the term of the lease, and that changed rent, what the schedule refers to as the new passing rent, isn't known and can't be determined when the lease is granted. So effectively, that Condition C, there's a rent that changes and that rent isn't known and can't be worked out at the time the lease starts. You'll see that Condition C mentions whether or not contained in the lease itself. So relevant rent review terms in a side letter, in some sort of personal agreement, or in some overarching commercial arrangement, perhaps, they would still be caught. Those are relevant rent review terms themselves. Now you'll notice that it says the rent will or may change and isn't known at the start of the lease. So a stepped rent wouldn't be caught. A stepped rent wouldn't fall within the prohibition. And that's the kind of rent where there is so much payable the first year, so much payable the second year, so much the third, and so on. But because the rent is known at the time the lease is granted, it won't be caught. nor would fixed indexation, for example, a fixed 5% increase year on year of the rent, because you can calculate that at the start of the lease. The tenant will know what they have to pay throughout. That's condition C. Then the last of the four conditions, condition D. And this is that those relevant rent review terms that we've just talked about contain two elements. The first is that the amount of rent, what the schedule refers to as the reference amount, is determined by reference to indexation or a multiplier, or by reference to hypothetical market rental comparables, or by reference to the tenant's turnover. Then the second element of condition D is that those relevant rent review terms, that the amount of the new passing rent, i.e. what the tenant will pay going forwards after the rent review date, will or could be different from the calculated reference amount. So the maths is done, the valuation is done, but the new passing rent isn't or might not be just that calculated or determined amount, but might be something else. For example, the higher rent already payable. So condition D deals with how the amount of rent, the reference amount, is determined, and it talks of rent and it doesn't define rent. And many leases have other payments, not just occupational rent, reserved as rent, such as service charge or insurance rent. So what if, say, we had a fixed service charge payable under a lease and that increased each year in line with RPI? So it's a rent reserved, it's not known throughout the term of the lease because it's rising in line with RPI. Would that be caught? I don't think so. There is no definition of rent in Schedule 7A, as I said, but remember we're in the context of the 1954 Act, where these new schedules are to be added in, and the 54 Act talks all about occupational rent. Though I do agree that the draft legislation could be clearer on that point. I think here we're talking about rent provisions dealing with occupational rent only. Now, in that condition D, it talks about ways in which the rent is worked out. One of those is tenants' turnover. There's no mention in condition D of that rent being determined by reference to the amount of the tenant's turnover at the premises, but presumably that must be the case. That's how leases are drafted. We take into account the tenant's turnover generated at the premises demised by the lease. But again, the draft legislation could be clearer on that point. So if those four conditions are met, it's a 1954 Act lease, it's a post-commencement tenancy, it has a rent that may or will change and isn't known at the start of the lease, and that changed rent is by reference to indexation or market review or tenant's turnover, but that new passing rent will or could be different from that reference rent. If those four conditions are met, Schedule 7A applies, and in particular, the all-important paragraph 6. Paragraph 6 applies in relation to a particular rent review if the amount of the new passing rent, what the tenant will pay in the future, determined in accordance with the relevant rent review terms, would be larger than the reference amount. It applies also in cases where the amount of the new passing rent would be smaller than the rent under review, but still larger than the reference amount. And if paragraph 6 applies, the relevant rent review terms are of no effect to the extent that they would result in the new passing rent being larger than the calculated reference amount. Instead, the amount of the new passing rent is to be the same as the reference amount. So we need to unpack that paragraph 6 and consider each of its elements in turn. So paragraph 6 applies if, having done the indexation, the valuation according to open market rental comparables, the maths of the turnover. So if having done one of those and so worked out the reference amount, if the rent review drafting would make the new passing rent, what the tenant's going to pay from rent review date onwards, greater than that reference amount, perhaps simply by saying, as per usual, that the new rent can't be less than the rent payable immediately before the rent review date, then that element of the rent review provisions will be ineffective. It's not an actual ban on upwards only rent review drafting. It simply renders ineffective any drafting to the extent that it would mean that the new passing rent is higher than the calculated rent. And it's not just a ban on upwards only rent review, it also renders ineffective any drafting that might look to limit how far a rent might fall at review time. So not just upwards only ban, but also stopping floors. So having considered the four conditions in turn and what paragraph 6, the prohibition, actually says, let's take some of the most common rent review mechanisms we presently see and see how paragraph 6 will apply to them. A typical open market rent review will work just fine, save of course for the all-important line that states that the new passing rent will be at the higher of the rent reserved immediately before the relevant review date and the reviewed rent. The reviewed rent will instead just be the new passing rent. The line about higher be ineffective. The notional amount calculated as rent for the premises on a hypothetical letting can still include all the usual assumptions and disregards, but once the valuation has been done, the relevant rent review terms can't make the new passing rent a higher figure. Of course, the new market rent might well be higher than the present passing rent if the market has risen. It might be just higher anyway, in which case the new higher rent will be payable. If the market has fallen, though, the higher of drafting will be ineffective. The new passing rent will be the assessed market rent, regardless of the drop. Then on to rent review by indexation. Perhaps a rent review that provides that the annual rent is subject to indexation tracking the retail or consumer prices index. So if we have rent review drafting that does just that and just follows RPI or CPI, then it won't be caught. But that assumes that the drafting is such that if indexation falls, if the RPI or CPI drops, the rent will be allowed to fall. If you have the usual wording for indexation drafting that the rent will be the higher of the indexed rent or what you were paying before, that higher then will be rendered ineffective. Indexation, though, of RPI and CPI has only ever been negative on two brief occasions in past many years. So effectively indexation is upwards only regardless. But of course it does track prices rather than rental value. The landlord ends up with an equivalent rent, but maybe not a market rent. Sometimes we see a rent review changing the rent by reference to CPI plus 1%. And as condition B refers to rent being determined by reference to inflation or any other index or multiplier, it seems that CPI plus 1% or similar would just be another multiplier. So using that to calculate your reference amount should be just fine. The new passing rent calculated that way, there's nothing in the rent review terms to say that the new passing rent would or could be any different to that CPI plus 1%. But I do think that the draft legislative provisions could be clearer on that point. CPI plus 1% is becoming an increasingly common mechanism of rent review. Frequently, of course, indexed rents have a cap and a collar, so that a rent changes in line with CPI, say, but with a cap on the increase of 4% to protect the tenant against rampant inflation, and a collar on the increase of, say, 1% to protect the landlord against deflation. Well, when Schedule 7A applies, the cap will still work. The relevant rent review provisions are only rendered ineffective to the extent that they would result in the new passing rent being larger than the reference amount, but the collar wouldn't work. It is a way of keeping the rent higher than it would otherwise be. Even a cap of 0% to keep the rent where it is would be rendered ineffective if in fact CPI had fallen. Now, the accompanying notes to the bill do recognise that collars have their place in indexed rent reviews in some sectors of the real estate market, and maybe that's something for which we might hope to see an exception in due course. Then on to rent review where rent is calculated according to the tenant's turnover. We wouldn't normally consider the calculation of turnover rent year by year as a rent review. It's just working out the rent, but it does fall within the definition of relevant rent review terms. The amount of rent may or will change, and the amount of rent isn't known and can't be calculated at the start of the lease. That's turnover rent, so it does fall within the definition of relevant rent review terms. So paragraph 6 and its prohibition has to be considered each time we calculate the turnover rent. So if turnover rent is calculated in the usual way, say X% of the tenant's turnover generated at the premises, and if it's done so that it can rise and fall, that turnover rent will be just fine. But paragraph 6 and its prohibition would mean an end to ratcheted turnover rent, which we sometimes see. That ratcheted turnover rent where the tenant must pay either the higher of the turnover rent calculated for this year or the turnover rent that it paid in the previous year. So if the drafting of the legislation stays as it is, we won't be able to have those ratcheted turnover rents. Of course, often there's a base rent payable alongside a turnover rent, perhaps a discounted percentage of the full open market rent for the premises, but a base rent that is payable regardless of whether the tenant's business does well or not. If that base rent is reviewed on an open market basis, then it will be caught by paragraph 6 and will have to go up as well as down. If there's a turnover rent that is completely independent of the base rent, then the rules will apply to both separately. Now, if the base rent is fixed or a stepped rent, so either we know what it's going to be throughout the term of the lease, or we know that it's going to increase in known increments throughout the term of the lease, then the base rent won't be caught by paragraph 6. That sort of base rent won't be caught by Schedule 7A. There's a common scenario that the turnover rent is calculated as the amount by which a particular percentage of the turnover exceeds a base rent payable. So the rent the tenant pays is the base rent plus a turnover top-up. Independently assessed, so long as both base rent and turnover rent can go up and go down, they fit with paragraph 6. But if paragraph 6 works to override a lease and allow the base rent payable to fall, if that base rent is based on an open market rent and somewhere it says it can't go down and paragraph 6 says, no, that's not right, you'll have to let it fall, the tenant will end up paying a greater amount of turnover rent. Because if the turnover rent is, say, 10% of the turnover in excess of the base rent drops, then they'll be paying more turnover rent. What Schedule 7A will prevent by way of base rent would be replaced by a greater amount of turnover rent. But, and there is a but, we have to consider paragraph 10 of the schedule. Paragraph 10, Schedule 7A, is anti-avoidance. Any agreement, whether in the lease or not, is void if and to the extent that it purports to require the tenant to make a payment in respect of any difference in the amount of new passing rent which results from the operation of any provision of the schedule, which is a long and complicated way of saying that if the schedule lets the tenant off paying something, the lease can't then provide for the tenant to pay something else to make up for that. So we're going to have to look at the likes of base rent and turnover rent, where the base rent is assessed according to open market very carefully. I'm cautious because I think it all depends on the individual drafting of an individual lease. So it's well worth running the draft legislative provisions over the exact current drafting of your present lease. And I think we could do with greater clarity on that point. But I wouldn't say that base rent plus turnover rent will be prohibited at all. I don't think that's the case. If your base rent is fixed or stepped and your turnover rent is allowed to go down as well as up, then it'll work just fine. A brief word about the other paragraphs of Schedule 7A. Paragraph 7 allows for exceptions to paragraph 6, exceptions to the ban, and the Secretary of State may make regulations allowing those exceptions. So we'll have to see what happens there. Paragraphs 8 and 9 deal with a tenant being able to trigger rent review and a tenant being able to take whatever operational actions are required to enable that rent review to operate effectively. And those paragraphs are a result of lessons learnt when Ireland adopted a ban on upwards only rent review and some landlords moved to rent reviews that could be triggered only by landlords, and of course the landlord didn't trigger the rent review in a falling market. So paragraph 8 allows a tenant to trigger a rent review simply by serving notice in writing on the landlord, and paragraph 9 allows the tenant to carry out whatever operational actions are required to make that rent review happen, perhaps appointing a valuer, for example, or going to expert determination. So those are the remaining important provisions of paragraph Schedule 7A. Just lastly, I'm conscious of the fact I haven't mentioned Schedule 7B, the whole of Schedule 7B. And briefly, the intention of that whole schedule is to prevent a landlord requiring a tenant to sign up to a lease and also at the same time to sign up to an agreement for lease, leading to a second lease with an initial rent based on indexation, market rent, or turnover. A way of avoiding the need to include relevant rent review provisions in the first lease and so running into the ban. So Schedule 7B only applies if what the schedule calls this put option, which could just be an agreement for lease, if this put option is entered into after the schedule comes into force. So agreements for lease entered into now with existing tenants won't be caught. For that second lease, if you oblige the tenant to enter a second lease, the method of determining the rent will be of no effect to the extent that they result in an initial rent being larger than the reference amount, i.e. what you get from indexation, valuation or turnover. So there's no way of saying that the rent must be at least the rent payable at the end of the first lease. That is in itself Schedule B, 7B, anti-avoidance. We can't allow a landlord to sign up a tenant to a lease and then an agreement for lease committing it to a second lease as a way round, including prohibited upward only rent review provisions in the first lease. So that's a run through the technicalities of the provisions, the four conditions that have to apply for the ban in Schedule 6 to take effect. It's our review of the technicalities of the draft legislation, and perhaps we'll revisit it as and when, or perhaps if and when, Schedule 31 makes it onto the statute books. Many thanks for listening.